So in your book, you define capitalism as and I quote, legal regime that enables the appropriation of collective resources, including the law itself, for private gain.
So in my previous book, The Code of Capital, I have shown that capital exists only because you combine certain types of assets, a piece of land or a promise to future pay, or an idea with the right legal coding. You use property rights so that you can actually monetize the value of land. Otherwise, you can use it, but you can't really sell it. You use intellectual property rights to turn ideas into monetizable assets. You use other legal features, corporate law, to create legal persons that can accumulate capital, etc. So capital, in my mind, does not exist without the legal coding. And that also then, I think, extends to the system of capitalism, which operates because many people can use the legal coding and rely on the enforceability of the law and can invoke litigation and law enforcement against others to build their own private power base. So to some extent, I'm just simply saying, let's just strip away what capitalism and the capitalists have done with our legal system. They've used something that was originally created for a piece of land or a cow or a plow and converted this into something that is usable for financial assets. And I think one could also, however, use the law for very different purposes. And there are many aspects in existing private law too that allows you to organize, let's say, co-ops, or to use private law to impose obligations on others, like in fiduciary duties that we have in corporate law. So you can't just do whatever you want when you manage other people's assets. You're bound by certain principles. And what I'm essentially saying is we should probably extend these principles of reciprocity and respect for others beyond the narrow realm of fiduciary duties, for example.
So when you say the capitalists have done this, I want to break down a little bit what that means. Was this intentional? And if it was intentional, who intended it? Did states intend it? Did original capitalists intend it? Or is this a system of sort of like a Nietzschean will to power, where the capitalist will to profit just sort of becomes, if that makes sense?
So I think it's not a grand design. Basically, I think the techniques that were originally developed when we enclosed the land and created individualized property rights for some owners over others, that allowed them to exclude others and to reap the profits from the land for themselves and nobody else. The same techniques have over time been employed to code other assets as capital. The same thing. Over and over. You basically enclose some assets where ownership rights are not entirely clear, the commons, intellectual property rights, our data. Then you claim that they're yours. And then you try to develop the legal arguments to defend this, typically with a good lawyer on your side. So in England, you had the country lawyers that did the conveyance of land, which became a completely complex thing that nobody else understood but them, right? So lawyers are always part of it. They are also part of the, rent seekers, some people would call them. And the state is implicated as well. It's not that the state is outside of that. It's implicated, of course, through its judiciary, because they do enforce these rights. So when they recognize new codings of capital, or allow strategic litigation to go forward, they basically vindicate what private practice has done. And they also, when some of the practices will be challenged by others who might suffer from that, then it very much depends on how they come out on either side. So I think through this decentralized process of trial and error, but also having the right resources to hire the right lawyers and to push the next frontier of asset enclosure, that's how capitalism has evolved over time.
What I understand is that your complaint is not about the fact that private law applies between me and Bethany, because by and large, we are people with the same bargaining power, same position, the same information, everything said. In where we need a difference is when we deal with large corporations, because large corporations are almost like small private governments. So we will need a third branch of law, as we have the public law is different from private, because we're dealing with a entity that has enormously more power than we have, and so we need to be protected against them. And so in a sense, we need a new branch of law for the interaction between normal consumers and corporations. But maybe the private law as it is fine between corporations themselves because they are more or less equally powerful. But when it comes to a consumer or workers with a corporation, the asymmetry is so large that we need a quasi-public law.
Yeah, it could be either quasi-public law, and the European Union has done something along those lines because it regulates, for example, consumer protection much more so than what is done here in the United States, and has been, I think, quite successful in doing this. So, to get out of contracts if they're unfair within a period of time, et cetera, et cetera. I think I'm trying to go a step further and basically say that even in the relationship between the two of you, I would say that we should have, principles of fairness and reciprocity built into this. I have to respect the others. I can't just take advantage of others. And even if you're not a big corporation, you can also, as an individual, be quite ruthless in the use of private law, which is not necessarily, the way in which private law has always been under all consideration. So I'm basically trying to rescue private law from its having been turned into a black letter device that has been stripped of its normative foundations and has been used primarily sort of to, work for the advantage of those who know how best to use it. But basically, I want to give it a new type of normative foundation that is better also aligned with our ideas of democratic self-governance and etc.